Living Local Carolina with Katie Turner. Local trends, shopping, dining, and more. This is Living Local Carolina.
The following portion of Living Local Carolina is sponsored by Beach Injury Lawyers.
Well, good morning, everyone. I'm so glad that you're here because I am joined yet again by the guys from Beach Injury Lawyers, the dynamic duo, Will and Greg. How are you guys doing?
We're doing well. Good morning.
Good morning.
Hey, Katie, doing well. How are you?
I'm great. Okay, before we dive into today's topic, let's give a refresher on who you guys are and what are you doing here?
Go ahead, Will.
All right, we are Beach Injury Lawyers. We are a law firm who handles injury law, personal injury cases. I have been in this area since 2000, been practicing since 2006 for various firms, opened my own law firm in 2017, practiced solo. I had another attorney at one point, but ended up partnering up with Greg in 2021, and we reformed, rebranded, and now we are Beach Injury Lawyers.
Love it.
So let me see. So I've been in South Carolina since, high school. So that was 1979.
Quick math here.
Yeah, and you don't want me to do math on the air.
Big math.
So I've been in Myrtle Beach for about 3 years, and I came from Greenville. Before moving down to Horry County, and I've been practicing since 1996.
All right. Well, I'm Katie Turner, and I'm here to interview them about workers' compensation today. So why don't one of you tell me, firstly, what type of injury qualifies on the job as a workers' comp case?
Sure. Okay. There are a couple of requirements. One, the employer has to be subject to the Workers' Compensation Act. They have to have workers' comp insurance. Any employer who has 4 or more full-time employees is mandated to have workers' comp.
Gotcha.
So that's, first they have to be covered. The next thing is just to be injured on the job. So that's the great thing about comp. The great part of it is it's very, very broad coverage.
Yeah.
Anyone injured almost for any reason is covered. The few limitations would be intoxication and causing a physical altercation, where you kind of cause it. But even if a third party causes the injury, if you're working, you're still covered under comp. And if it's an accident or any of that, you're also covered. So yeah, very, very broad coverage.
Okay. Well, Greg, could you give me some kind of specific examples, maybe?
Well, for the ones that we see, with the firm, we had a recent case come in where someone had, on a bandsaw, they had almost severed their arm. And so that obviously is a workers' comp case. One of the largest cases I think the firm has ever handled, or you had handled, was a workers' compensation case where a motor vehicle accident occurred. And so not only could the injured worker file for workers' comp benefits, but they were also able to file a claim, sue the driver that caused the accident while he was on the job. So, you're not always limited to just workers' compensation. If a third party causes it, if another person causes it, like I say, in a driving situation, then you're able to pursue that person as well as comp benefits.
Here's the benefit of a third party being involved. While there is broad coverage, and if they have workers' comp insurance or subject to have it, and you're injured, you will be covered. However, there are limitations. So very broad coverage, but limitations are there's no pain and suffering. You're not awarded for that. There's no jury trial. There's no judge. There is a commissioner who are appointed by the state, and they oversee workers' comp hearings. The determination of value of a case depends on the amount of money that you make. So if you're working 25 hours a week and you're working for, let's say, minimum wage, versus you are working 40 hours a week and you're in a very skilled position where you're making $50 an hour, there's a difference. The amount you make is part of the equation. You're entitled to 2/3 of your average weekly wage, so you're not getting all of your money in the first place. So there's a little bit of limitation. It's not subject to taxes, but you're losing a little bit in there.
Interesting. All right, thanks guys. Stick with us because coming up after the break, we're going to talk about what next steps you should take if you actually get injured on the job. We'll be right back. Welcome back to Living Local Carolina. I'm joined by beach injury lawyers, and we've been talking about workers' compensation. So why don't you guys tell me, if somebody is injured on the job, what are the next steps they need to take?
Sure. The first step is to notify the employer. There is a 90-day notice requirement, so you have to notify them within 90 days. That notice can be verbal, it can be written. Documentation would be smart too. I would email my employer, or just they're going to send the employee to receive medical care, so that would be proof. That's the first step. You have to bring the claim within 2 years, but the notice requirement is the first thing, so within 90 days. The next step would be to contact an attorney. Things can happen really quickly in a case that can cause problems if you don't retain an attorney.
Yeah.
After you notify the employer, there's some things to kind of keep in mind. Some of the limitations, I said, the coverage is very broad. You're going to be covered, but the employer has rights, and typically they're insured, the insurance company for the employer has a lot of say in your medical treatment. They're able to direct your medical treatment, so you don't necessarily get to choose your doctor. You can request a second opinion, but you're not able to say, this is the doctor that I use. I really want to go see Dr. So-and-so. That's not, unfortunately, you're not allowed. They have to have a contractual agreement with the insurance company and be an authorized provider. So that's part of it.
What if you're worried about actually making the claim itself? If you're worried about retaliation, what have you?
Sure. That is a fear that we see a lot. Yeah, we see, and justifiably so. There are laws in place that prevent retaliation if the retaliation is solely based upon them being injured. However, we are, right to hire, right to fire state. So, frankly, employers could get around that anyway. But in terms of just being able to, be fired or be retaliated against solely for being injured on the job, the employer is not allowed to do that.
Gotcha. Greg, what else do you think people need to know?
Well, and you can probably tell by I'm normally not this quiet, but Will's really he's our workers' comp guy. But injured, when you're injured on the job, I took a call yesterday, and it was a 15-year-old that had been injured, and the mother was she was afraid to whether she should make a workers' compensation claim on behalf, of the son. And you have to overcome the fear, because what you have to do is you got to do what's in your best interest. If you don't look after yourself, if you're not looking after your own interests, I assure you no one else will.
Yeah.
So if you are injured, you definitely need to call. Again, if not, we would prefer you to call us, but if not, call an attorney. I mean, that's what we're trained to do, is to help you in those situations.
We haven't really talked about this, but this is something I'm interested in, is the typical timeline of this. You said 90 days between when you need to actually file the report, but how long does this process typically take?
Sure. Okay. So that's, I hate to give you an answer that's
yeah.
not, but it depends on the injury.
Yeah.
The treatment is what dictates either a personal injury case or a workers' compensation case. So however long the person treats is going to be the primary factor. After that, in a workers' compensation case, typically you're going to receive an impairment rating by your doctor, which is, to make that simple, it's how much have you lost the ability to use that body part. So I gave an example of 20%. So if you've lost range of motion and you lost strength, the doctor will assign an impairment rating based upon some guidelines that have been created by the American Medical Association. So after that typically settlement at that point, it depends if there's if we're arguing over the settlement numbers and you file and request a hearing, you're talking about another 90 plus days and so forth. If you're able to resolve the claim amicably between the two parties, then settlement can happen within a month or so.
All right.
In a perfect world.
In a perfect world. Well, thank you guys for sharing. We've got a little bit more coming up after the break. We're going to be talking about Social Security disability. You don't want to miss this. We'll be right back. Guys, thanks for sticking with us today on Living Local Carolina. I'm back with the guys from Beach Injury Lawyers. We've been talking about workers' compensation, but we're also going to talk about Social Security disability and kind of the nuances there. Who wants to talk first?
I mean, Will's going to talk more about Social Security disability. I did want to mention we had talked about, workers' comp and third-party claims in the last segment, but there are occasions where you get both a comp injury, where you have a third-party claim against the person that caused it, and then depending on the severity of the injury, you can also bring in Social Security disability. So, and again, that's what happened with one of the largest cases that this firm has handled, where you had workers comp, third-party case, and Social Security.
So they can go hand in hand, but they don't always.
They don't always, and it can be tricky.
Yeah.
If you know that you're going to apply for disability, it can affect your workers' comp case, and you absolutely need an attorney if you're in that situation. I'll just say that.
Okay. Gotcha.
But as for disability itself, that is what I started my career doing. The first 3 years, that's all I did, and I've handled well over 1,000 hearings. So Social Security, to give just like a broad overview, the main question is this: Are you able to work? Are you able to engage in what's called substantial and gainful activity for 40 hours a week or on a full-time basis? Substantial means that you actually are doing the work, physically working, or in that capacity, and gainful means you're making money. So those are the two, kind of simple, but those are the two things. The Social Security Administration has broken down, there's two programs. I don't want to get too technical, but there's Social Security Disability Insurance, or SSDI, and then there's Supplemental Security Income. Both require you to not be able to work, okay? Supplemental Security Income is, it supplements your income. So what that means is you haven't worked enough, or you haven't worked in the past 5 years, so you have not built up insurance by paying into the system. However, if you are disabled and you're not able to work, the government will still assist you. It's just a lower amount, and there's a resource limit. You can have a vehicle, you can have a home, but frankly, you can't have much else. You can't have more than $2,000 in your bank account, and if you have more than that, it will actually reduce the amount you would get that month. So it's there's limitations.
I see. We've talked about this before, but the steps that you need to take, what does that look like if you want to apply?
Sure, yeah. You can apply online, or you can call the local Social Security office and make an appointment to do it over the phone. We do have clients or potential clients call us and ask us to do that for them. And here's what I typically tell them. In Social Security Administration cases, we are entitled to a fee of 25% of their past due benefits.
Okay.
Okay. So for me to do their application, I don't know the answers to the application. They do. So I would be assisting them with that. But for me to get 25% of, if they allege disability a year before, which they can do, and there's 12 months of disability, and they're awarded, and it takes a couple months to award it, so there's all this money, I would not feel right taking 25% of all of that money. I ask them to typically apply themselves. And then if they're denied, that's when really an attorney can actually do something to help them more than just simply applying. Some tips if they're going to apply is go ahead and get your medical records, and you can ask your doctor to write a statement saying that if they believe you're disabled. Those are things you can do when you apply that could at least help your chances. The other thing I would say is they're going to send you typically to a physician to be examined,
Yeah.
sometimes mental health, sometimes physical, or sometimes both. Make sure you make that appointment. If you don't make that appointment, they have a reason to deny your case.
All right. Well, regardless of your situation, if you are watching right now, you guys have free consultations. How can people get in contact with you?
Absolutely. Just give us a call at 843-357-4111 or look us up on the web at
Yep. www.beachinjurylawyers.com.
And on Instagram.
IG.
The preceding portion of Living Local Carolina is sponsored by Beach Injury Lawyers.